Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor.
Law firms will take this as a retainer.
What? It must be a law firm where they hungry as hell. Now you gonna help me with this parole I'm dealing with?
Judge Joe Brown's all-new barbecue sauce and seasoning. Justice in the form of flavor. With one taste of our premium blends of all-natural ingredients, herbs, and spices, you'll fall in love with meat all over again. Judge Joe Brown's all-natural barbecue sauce collection is made up of 2 zesty flavors, original and spicy. There's only one way to bring order back to barbecuing. Just add Judge Joe Brown's all-natural barbecue sauce and seasoning, and you be the judge.
Good evening, everybody. So this is episode 4 of Injustice for All with Judge Joe Brown. And today we're going to be talking about the 14th Amendment. Judge Joe Brown will break it down, the 14th Amendment, section by section. We also going to talk about breaking news. Donald Trump allegedly rolled back 1965 Civil Rights Act by Lyndon B. Johnson, right? That's what's circulating around the news. Also, we will be mentioning and talking about the ACLU sues to block Donald Trump, birthright, citizenship, and deportation. So this is about the judge, not about me. And enjoy the show. But before we get started, guys, make sure you share this video, like this video, and subscribe to the channel and hit the bell button to get all notifications. Please comment and go to www.jjb.com to get you Judge Joe Brown barbecue sauce, or you could purchase it on Amazon. It's delicious. So, without further ado, hi, Judge. How are you?
Hello there. It's cold outside today.
Yes, it is. So that's why I have this on. This is something that you came up with, Injustice for All. You're going to be elaborating on whether it's the Constitution, whether it's something trending, whether it's a case, but just you breaking down whatever the topic is. And today is the 14th Amendment, because we all know Donald Trump was sworn in as the 47th president, and he signed 200 executive orders. And one of them was to eliminate birthright citizenship. So we kind of talked about that birthright citizenship. However, we want to draw the attention to the 14th Amendment. Now, do you want me to share this screen here?
Oh yeah, you can share it. No problem at all. Oh, what do we have here? Is this I can't see it. Is this the 14th Amendment?
Yes, I'm going to make it a little bit bigger, but
leave it up so people can look at it at their least. Okay. But here's the preeminent thing here that you need to understand about what you're looking at. Some people want to do things yesterday, right now, immediate, instant gratification, etc. That's not how the real world works. Now, when the Civil War is over, you have the 13th Amendment that frees the slaves, all right? It makes slavery illegal except for the classic circumstance as a punishment for a criminal offense. In fact, if you're locked up, you're enslaved anyway, because you don't have freedom of you don't have the freedom to do what you want. You're subject to somebody else's absolute control. But the 14th Amendment had to deal with this case called Dred Scott, which was a horrible thing, the opinion of which was written by an idiot named Taney. And it was still good law. And it said that Negroes / former slaves could not be citizens. So the 14th Amendment wanted to address that point quickly and say, if we're going to deal with giving these people rights as citizens, we have to clarify things so there is no question the Constitution now says they are citizens if they're born here. That was dealing with this enormous trove of former slaves that had been freed thanks to the Civil War and the 13th Amendment. It has a provision in there. It says all persons born in the United States not subject, all of the persons born in the United States who are subject to the jurisdiction of the United States. That seems to confuse a lot of people, but what it was doing was acknowledging a diplomatic reality, which is the children of registered diplomats are immune from this dual citizenship thing, because by ancient tradition and treaty, nations would have embassies, which are viewed to be the sovereign soil of the country that has the embassy there. And they have career diplomats or long-term diplomats who are assigned there, and they may have their families with them, and they may have children, and it becomes very inconvenient if they have children in the line of duty and the child is of dual citizenship. So that's why you have the provision subject to the jurisdiction of the United States, which means since ambassadors, their personnel, diplomats, those with diplomatic immunity are not subject to the jurisdiction of the United States. You can't prosecute them. You can eject them, say be gone, but you can't prosecute them for a crime because they have an immunity. I ran into that, and this is a very quick anecdote. I had a situation where there were some assassins came to liquidate some people that had discovered diamonds, and they had 7 individuals who were the targets. 5 of them were shot, 4 of them were killed, 1 of them was badly wounded. We are going through weeks of a murder trial, and we had to stop because the U.S. State Department granted them immunity, took them out of the Shelby County Jail, and sent them back to South Africa. So that's how diplomatic immunity works. Even if it's a murder charge, you can be granted immunity and you no longer are liable for the consequences. You can have much, much money in your pocket, way more than a citizen can pass through a border checkpoint or go through an airport with. And all that needs to happen is one of the diplomatic corps slaps a diplomatic sticker on it and it's off limits. So that's what that particular language is about. It's kind of a longhand way of saying you got diplomatic immunity and it doesn't apply to you. Your children, if they are born here in the United States, are not U.S. citizens. They still remain citizens of your country. That's what that's about, and why a lot of people get confused. But the problem is that a president can't undo the Constitution. He can urge an interpretation, and I understand what he's doing. I think it's legitimate. He issued a challenge, and we've already had quite a number of states and ACLU wanting to challenge what he's doing. So when a state is a party to an action against the United States, it goes directly to the United States Supreme Court. So it's on the fast track. I imagine what he's trying to elicit in the long term is a constitutional amendment. What is it, number 26, that would clarify what that language in the 14th Amendment is about. Now, one interesting thing, if anybody has taken advantage of that, come in under that, you can't undo that because the United States has this thing in its Constitution about ex facto laws. In other words, you can't make something illegal which has once been legal and somebody has come in under it. So if you are possessed of this duality of citizenship and your parents aren't, this thing about being an anchor baby, this thing about birthright citizenship. Actually, the terminology used is fairly recent. The solution to that, if nothing else works, is okay, you did it. You snuck in here, you committed the crime, you pay for it, which is in this case, you get deported, but the child is an American citizen. The child stays here. Bye-bye, we'll raise the child in the same way that, let's say you had somebody charged with federal crimes and they are a single parent with no kinfolk and they have to go to prison. Well, what do you think happens to the child? The child is taken by some form of Child Protective Services, Department of Human Services, and the child is put in an institution or fostered. It doesn't sound very nice, but it happens. I've even ordered it myself when I have had that situation with people I've sentenced and the guidelines say they have to go to jail. So it is what it is, and you can look at the parent saying you broke the law. You pay the consequences, and so do your children or your child. So we could do that. And as a matter of fact, the whole anchor baby concept is not constitutional. It's simply an urge or an effort to be humanitarian. In other words, we'll make an exception. We don't want to break up the family. That sounds so inhumane. Oh my God, we have to be civilized. So we will let them stay here if they have a baby here because we don't want to harm or diminish our young citizen over there. So that's what that's about. But I think we will see some long-term resolution. As a matter of fact, when you and I were watching him after he'd been in the Oval Office for 15 minutes the other day, when he was signing these executive orders, they asked him about that. And he said, well, there is a valid point there, but we'll see how it works out. In other words, go for it, see what happens. But something needs to be done about that because it is a loophole and it's out there.
I wanted to bring up the 14th Amendment before we move on any further, because the discussion of birthright citizenship and the deportation, that's going to be ongoing. But I need for you to kind of break down this 14th Amendment section by section so that people can have a very clear understanding. Do you need me to read this or can you see it?
I can see it. I put my glasses on. Look here. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of its law. See, the Fifth Amendment gives people the right to due process of law from the federal system. This established the same right of due process of law upon the state system. What this is subject to the jurisdiction of, in other words, you're not a diplomat with immunity, and nobody shall pass any law that abridges the privileges and immunities of citizens of the United States. That's still self-explanatory. And equal protection of the law is interesting, but it's important. In other words, nobody gets treated one way in part of the state and somebody else in the same situation gets treated a different way in another part. I used that almost 50 years ago to battle an idiot who was sitting on the bench who didn't meet the qualifications, and I raised that it was not equal protection for somebody in this part of the state to be entitled to a more mature individual over 30. And here in Memphis, we had somebody 27 years old who was arguably too immature to adjudicate criminal cases against him. So I won, and he got barred from hearing criminal cases. But that's a long story. Now, this other thing, as I said, this looks strange, but the context is the Dred Scott decision that said Negroes could not be citizens.
Well, I want to go section by section. So just let me know.
That's it. I just broke the whole thing down. Now let's go to section 2.
Yes, just tell me when you want to move on to the next section.
Going to section 2. Now move on. Move it down a little bit. I can't see that. Okay. Representatives shall be apportioned amongst the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. But when the right to vote in any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of his state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the United States, are in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. In other words, it sanctioned anybody trying to keep somebody from participating in this political process. So you couldn't. And this was a stated penalty. The rebellion referred to those who were in the Civil War. The idiots from the Democratic Party that started the damn Civil War, that started the real rebellion in American history, tried to brand what happened on January 6, 2021 as a rebellion. It was not. There were 180 people actively participating, and heaven help the United States of America if 180 people constitutes a rebellion that could seriously do anything to 340 to 360 million. Now, the other thing is that is a rehash of some language that's in the Constitution itself that offers the protections of the Constitution to everyone except during the course of 1, an invasion, or 2, a rebellion. The rebellion was not some people getting unruly during a demonstration. A rebellion is when you had large swaths of the public rebelling, when you had states withdrawing, when you had armies out there on the field. That is a rebellion. So this language was addressing those people who had been late of the Confederacy, which was in rebellion against the Union, which was successful. So that's what that's about. Most of the impact on that is obsolete, but some enterprising folk on the left are trying to bring that up. Now slide it down so I can see number 3. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or any other state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer in any state to support the Constitution of the United States, shall have engaged in an insurrection or rebellion against the same or given aid and comfort to the enemies thereof. But Congress, scroll it up, may by a vote of 2/3 of each house remove such disability. They did. Nathan Bedford Forrest, one of, the biggest slave trader in the South before the Civil War, Mr. Festus with the mostest, Confederate cavalry general of great fame for both his military brilliance and his viciousness, who engineered the massacre of black troops at Fort Pillow in Tennessee, not far from Memphis, became a U.S. congressman after he was charged with, on 3 occasions, with murder in the first degree of somebody white, by the way, but he was acquitted. All right, you have many American high-ranking military officers and generals who participated in, shall we say, the Spanish-American War, who had been officers in the Confederacy and had renounced their oath to the United States, but who were forgiven. So that legislation right there that they're talking about consisted of, do you take the oath to support the United States? We call it the Pledge of Allegiance now. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, and the original one did not contain under God. That wasn't interposed until 1947 to show our difference with communism. So one nation, indivisible, with liberty and justice. Now it says one nation under God, indivisible, with liberty and justice. So things have changed up, and that's been long established, let's say, for about 160 years. So nobody's going to touch that now. Let's see. Section 4, the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. This again is dealing with the aftermath of the Civil War. That is as short a distance from when this was proposed as it has been since Biden took office in 2021. So that's in perspective. It's a short period of time, and it again is obsolete because these conditions don't exist. And rebellion and insurrection have been long defined, and they do not, as aforesaid, include a fracas on January 6, 2021 in the Capitol building in Washington, D.C., which, by the way, has seen much worse over the last century. Let's go on to the next one. Section 5. Hold up. The Congress shall have power to enforce by appropriate legislation the provisions of this article. Okay. Now, maybe that gets into where Trump is going with his executive order to carry out the intent of Congress and enforce it. Perhaps they needed to have had some contemporaneous legislation to clarify that the birth thing only applied to the Negroes, and for that matter, it quickly got applied to American Indians who were taxed. You see that in there. So that they would be considered American citizens, and it would end forever all this dispute. They're not citizens. And then remember, you had a huge Irish contingent for both the Union and the Confederacy that had given sterling service in the Civil War, brave, above and beyond service in the Civil War. So a lot of them weren't born here. So it's a question of whether they get citizenship because they served in the Union Army, or whether they did this or whether they did that. And that was up in the air too. So you got a bunch of white people. Well, excuse me, not white people. Irish weren't officially declared to be white until a joint act of Congress, the House and the Senate, in 1878 that declared them to be white. So before that, they were considered non-white. That's an interesting little thing. But you see, you get people that we nominally consider white involved in this, which the current woke bunch don't even think about. So this included a lot of people. And that might be what he's trying to prompt, is an act of Congress to clarify that, since arguably they have the opportunity to clarify that with that last provision. And they also have a responsibility for declaring some things when it comes to naturalization, since the Constitution specifically gives to the Congress, House and Senate, the authority and the power to do that. So maybe he's trying to prompt that, but the president does not have the authority on an executive order to deal with that kind of thing. But I can see what he's doing to prompt action that would be taken.
One second. I'm trying to pull up the BirthRight executive, protecting the meaning and value of American citizenship. That must be it, right?
Well,
yeah.
you and I heard him talk about it, but live. So let's see if you pull it up.
Okay, let's see. Let me do it this way and make it bigger. 1 second. All right. Okay. So this is the executive order of the birthright citizenship that he wants to appeal or take away.
Protecting the meaning and value of American citizenship. What is this his executive order?
Yes. Did you want to read it? You want me to read it?
I'll read it. Section 1, purpose. The privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott versus Sanford. See, I hadn't read this thing, but yeah, that's, if you study law, which misrepresented the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. Okay, scroll up. So far, so good. But the 14th, down a little bit. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. Well, it says anyone subject to the jurisdiction of the United States, and if you don't have diplomatic immunity, you come in here and you commit a crime, you sure enough will be liable to being tried and upon due process of law convicted and punished for committing a crime. So that might be a little bit stretching it. The 14th Amendment has always excluded from birthright citizenships persons who were born in the United States but not subject to the jurisdiction thereof. I spoke on that, and that's key to this. That is a thing that is slipped in there to deal with the realities of diplomatic immunity and international custom and treaty. Diplomats, if they have children in the host country, do not have to worry about their children being declared dual citizens of the home country and that birth country if they have diplomatic status. They also are immune from the consequences of the host nation's jurisdiction. You do not prosecute them if they have already established diplomatic immunity for espionage, for homicides, for all sorts of things. You just expel them. And that's all you can do, because everybody's got this long-standing vested interest in protecting its ambassadors and its diplomatic corps. And that's not new. That goes all the way back several thousand years to ancient Egypt, what was going on in Mesopotamia with Ur, Babylon, Samaria, you name it, to ancient Europe, and it comes up fast forward to now. So Article 1, Section 8 of the Constitution says that the government of the United States is supposed to enforce the law of nations. And that, in fact, is a law that has been long the law of nations, or a principle. And also Article 6 of the Constitution says part of the supreme law of the land on the same level as the Constitution are those treaties that have been ratified by the Senate. And these issues had been ratified by the U.S. Senate through various treaties in the 7 years plus that led up to the point in time when this was propounded and submitted to the states for ratification. So we are
reading this.
Go ahead.
Okay, this is the next part of the executive order of the birthright citizenship.
Okay, policy. Raise up. It is the policy. Oh, scroll down a little bit. It is the policy of the United States that no department or agency of the United States government shall issue documents recognizing the United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to persons, one, when that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or a lawful permanent resident at the time of said person's birth, or two, that the person's mother's presence in the United States was lawful but temporary. That would impact Kamala. And the person's father was not a United States citizen or a lawful permanent resident at the time of said person's birth. Again, Kamala. Now, subsection A of this section shall apply only to persons who are born within the United States after 30 days from the date of this order. That's exactly what I said. I haven't read this thing, but I mean, that's the ex post facto. It takes place afterwards, because anybody that came in before, you can't undo what has been done. Water's under the bridge. You lose your virginity, you lost your virginity. You don't regain it. 3, enforcement. The Secretary of State, the Attorney General, the Secretary of Homeland Security, and the Commissioner of Social Security shall take all appropriate measures to ensure that the regulations and policies of their respective departments and agencies are consistent with this order, and that no officers, employees, or agents of their respective departments and agencies act or forbear from acting in any manner inconsistent with this order. Everybody get on board. You have no options. Now, it's interesting, stop there. The mayor of Washington, D.C., which is under federal jurisdiction, as a federal officer, has declared that she's not going to honor the pardons of President Trump relative to the January 6th people, that is, to the ones who are being held in Washington, D.C. detention facilities. This isn't the same situation in one sense, but it is in another. This is to clarify that there shall be no such clown shows as somebody saying, I choose not to follow along with this. This is a specific admonition. Now, definitions as used in this order. A, mother means the immediate female biological progenitor. Father means the immediate male biological progenitor. 5, Section 5, general provisions. A, nothing in this order shall be construed to impair or otherwise affect, 1, the authority granted by law to an executive department or agency or head thereof, or 2, the functions of the Director of Office of Management and Budget relating to budgetary, administrative, or legislative proposals. B, this order shall be implemented consistent with applicable law and subject to the availability of appropriations. In other words, Congress has to have provided the money, or the money has already been found that can be allocated for the use of the purposes of this order. This order is not intended to and does not create any right or benefit, substantive or procedural, enforceable at law or in equity by any party against the United States, its departments, agencies, or entities, its officers, employees, or agents, or any other person. What does that mean? It's simply stating with clarity that this does not remove sovereign immunity of officers, appointee, or elected or officials of the United States, nor of the United States itself. See, in other words, there is sovereign immunity by these entities unless it is waived or specifically stipulated that the United States or these officials will have liability. Okay, excellent order. It's on all fours, and as I suspected, it was going to deal with that last clause, which is the implementation aspect of the 14th Amendment being left up to Congress, the House, and the Senate. And that's what he's trying to approach.
All right. So
that might work, actually, after taking a look at that order. It complies with what I knew of the 14th Amendment, and I suspected it was going to go to Clause 5.
Well, we do have some breaking news, but before we get into the breaking news, I want to share this. So when he did issue that executive order, the ACLU sues to block Trump's expansion of fast-track deportations, right? So all those executive orders that he issued, the lawsuits start coming. So American Civil Liberties Union, ACLU, and 2 of its chapters are suing to halt President Trump's attempt to expand fast-track deportations without full hearing.
Okay, that's due process of law. He's wanting to deal with it in a summary fashion. The problem is that you have a situation where somebody who's come in here legally, and the question comes up is, subsequent to that legal entry, you have some administrative matters, some confusion, whatever they're entitled, obviously, to due process. That's just the way things are done. But you have this thing here where, subject to the jurisdiction of the United States, is in the 14th Amendment. The Supreme Court has held that even if you are a foreigner, if you are tried here in the United States, you have a right to due process of law, because that's how we do it. I say, old fellow, it just isn't done any other way. You know, it's not cricket, you know. That same British spirit there, the Anglo-Saxon thing that goes into American law. So we just don't do it certain ways, even if the person is not a citizen. So what they're talking about is due process of law. Now, what happens here is the comeback is, under the circumstances, there is a secondary thing called administrative due process of law. In other words, you might not make it to a court or be entitled to go to a court, but whatever the agency has up as to how it does it is supposed to be done. Now, here is the other thing. What we're going to probably see is that in his role as commander-in-chief, he's going to do something like what Roosevelt did with the Japanese. He's going to sign an order directing that all persons of known Japanese descent be confined to camps because they constitute a threat to national security. Now, that was just bad, but we do have all of these people who have been let out of prisons, who've been convicted. I think there's 19,000 of them known to have been convicted of murder, who have been admitted into the country. known to have been admitted into the country, but we don't know where they are. That figure may be as low as 12,000 in some accounts, and we have somewhere north of that in terms of known drug dealers, and they are in the country. We have many rapists, many of them who have been convicted of rape, many persons who've been convicted of rape. They're in the country, and those are the ones that were initially semi-vetted, but we don't know where they are. So it's just a matter of national security. You have, let's see, I think the total is somewhere around 1 million to 1.5 million military-aged Chinese males who, coming from China, as most of them who are interviewed indicate, they are subject to universal military training, and they are under an edict to cooperate with the Chinese military for the rest of life. They're here. They're in organized units of about 45 or 50, which is platoon size. They're broken into subunits, which correspond to fire teams or squads. And they have a peculiar thing with certain uniformed light camping stoves that they camp together and utilized in uniform light camping equipment, which is suspicious. And Taiwan has declared that by 2027, not Taiwan, Xi Jinping has declared that by 2027, it's going to get Taiwan. So that looks like there's a likelihood of hostilities. And the problem with that is the number of military-aged Chinese who've been admitted into this country exceeds the available number of U.S. personnel who either serving actively in the regular military units or in the reserve units or National Guards. It exceeds the number of them who are available, and that's just really kind of weird. Now,
let me read this real quick with that article.
Where the point is, it's a national security issue.
Right. So it says, a quick catch up. The Trump administration issued a new rule this Tuesday that dramatically expands expedited removal to immigrants who cannot prove they have been continuously living in the U.S. for over 2 years. The new rule allows U.S. Department of Homeland Security to decide expedited removals with limited exceptions of immigrants who can't show proof to satisfaction of immigration officer. The effect of this change would be to enhance national security and public safety while reducing government costs by facilitating prompt immigration determinations. But the ACLU said in court documents that the new rule violates current federal law and the Fifth Amendment's due process clause, since it nearly erases full court hearings entitled to immigrants. Quote, the expansion means that low-level DHS officers can now immediately and without process subject individuals in the interior of the United States to expedited removal without any consideration of their family ties. The ACLU also said previous studies show current expedited removals are plagued with error and often result in deportation of immigrants by mistake. But this is my question to you, Judge, because this is separate from the birthrights. However, how can somebody who came here illegally, which means they broke the law, be considered to have due process?
It's been long established. If you're in the United States, you have a right to due process. Like I just got through.
Whether you broke the law or not.
Yeah, in fact, the determination of whether you broke the law has long been determined. In other words, there are certain ways we do things irrespective of what the situation is. Now, here is the thing. Either ACLU is going to get an injunction or the process is going to continue and a whole lot of people are going to be booted out by the time it gets into court. However, what is the remedy if the Trump administration doesn't stop this? The remedy is ancient and it is long honored and it has been put to use an awful lot. You know what that is? The procedure of habeas corpus. Now, there is an interesting thing about that, since we brought it up earlier. The habeas corpus right exists in all times and in all places in the United States except two. One of them has to do with why these idiots were trying to use this language for January 6th, which was during an insurrection, which basically is a civil war and not 180 people in a demonstration. That would cause the right to a habeas corpus to be suspended. And the other is during the course of an invasion, the right to habeas corpus is suspended. And also, that's been interpreted along with some other things in time of declared war. Now, here's the thing. When you get 50 million people, the size population-wise of a moderately sized foreign country, invading the United States in mass, in caravans, coming across with the purpose of entering the United States. Here's what's happening. ACLU either gets an injunction to stop the federal government from doing what it has published through these executive orders that it intends to do. All right? I doubt they will get that injunction. What then happens is the current administration starts hitting heavy on this roundup, sends these people out of the country, and by the time the ACLU actually gets in court and starts getting a hearing on the matter, it's too late. These people are gone. Now, if they want to get in, they're going to have to go through the habeas corpus procedure. Under American law, the right to due process is not dependent upon your citizenship status. Anybody that's in here is entitled to due process because that's just the way we do it. Now, that being the case, the habeas process is suspended in two instances. One, where there is an insurrection, which is a civil war, not 180 people in the Capitol building on January 6, 2021. That's not an insurrection. And the other one is during the course of a foreign invasion. War of 1812. Think of that, when the Brits landed and captured New York and burnt down the Capitol building, well, the White House in Washington, D.C. All right, now, we have arguably an invasion. We have almost or above 50 million people, the population size of a typical nation, foreign nation. They lined up in huge caravans and they crashed our border. That's an invasion. They had no right to be here, no legal authorization to be here. They came across the border, and that is an invasion. So that arguably would suspend the right to a habeas corpus. So if there's no habeas, there's no way for ACLU to stop this unless they get something expedited. I suspect that they're going to jump in on the coattails of the states suing the federal government, which, as a fact, expedites all matters, goes through a fast track thing where you don't go through the district courts, you don't go through the circuit courts of appeals, you'll go to the Supreme Court. So they'll probably file an amicus brief on their points. But I think that it's going to be too little, too late, and it'll be done. And the other thing is the American people have given something of an absolute mandate. The situation is not favorable to what they're doing. And the other thing, step at a time. 6, 3, 1, 2, 3. will go against it and probably 6 for it, meaning the Trump position.
The Supreme Court. Okay.
Yes. Probably, but not necessarily.
So let's go back to the birthright, because the ACLU lawsuits were more so of the deportation executive orders that he signed. And that's not going to stop the deportations, what's going on right now, and it shouldn't. But now let's go back to the birthright, because this is breaking news, right? Judge temporarily blocks Trump's executive order on birthright citizenship, calling it blatantly unconstitutional. So I want to play this video clip real quick.
That's the lower court. That's going to be quickly overridden, because there's going to be a fast track to the Court of Appeals for the circuit, and then that's going to the Supreme Court. That'll last maybe a week, and I think what's going to wind up happening is it's going to be essentially ignored, because somebody's going to trot over to the Supreme Court building and get one of the many justices over there out of that panel of 6 I was talking about, who will dissolve that.
A federal judge in Seattle just signed a temporary restraining order blocking Trump's executive order on birthright citizenship that he signed on day 1 in the Oval. The federal judge in Washington state calling it a blatantly unconstitutional order. Lawyers representing the 4 Democratic-led states leading the lawsuit saying they're thrilled about this block.
We are thrilled that the court saw the seriousness and the urgency of the complaints and requests for a temporary restraining order brought by the state of Washington, Oregon, Arizona, and Illinois, and are thrilled that the judge issued a temporary restraining order directing the United States government to take no further action in enforcing and implementing the unconstitutional and un-American executive order attempting to eliminate birthright citizenship in America.
Joining me now, White House correspondent Mary Alice Parks and our Matt Rivers, who's along the border there in San Diego. Well, the blocking has begun. Mary Alice, let's talk about the reasoning the judge gave for blocking Trump's order.
Wait, stop one second.
It took him only 25 minutes.
Stop this a second. Now, see, the press is obfuscating the real issue. The parent who is an illegal is not the one we're talking about. We're talking about the child. So technically what happens is the parent doesn't have standing to raise this. The child does, or somebody on the child's behalf. So the remedy is take the child into protective custody at this point, because if in fact it has the birthright status, which by the way, is not contested in his order. Remember, this will only take effect 30 days from the date of this order signing. So we have somebody that does have advantage of the birthright citizenship, using the colloquial term, which isn't used in the 14th Amendment. Take them into protective custody and deport the mama or the dad. So you can do that. You see, the other thing is, if they're in here illegally, they invaded. They broke the law. And what's the precedent for that? Oh, War of 1812, when the nascent United States Army went up against the Army of Britain, the Redcoats. What did they do? They turned them back. They turned the invasion back. They ran them off. When that clown Andrew Jackson, who was a great general, it seems, was down in New Orleans, and he recruited pirates and black folk and everybody to fight the English down in New Orleans. He turned back. They got on the boat and left. See, that's the same kind of thing. You got an invasion, turn it back.
I'll finish playing the rest.
This is a judge that was appointed by Ronald Reagan, and he basically laughed the Trump team out of the courtroom. He said, I have difficulty understanding how a member of the bar can state unequivocally this is a constitutional order. It boggles my mind. Of course, the legal experts I talked to leading up to this hearing agreed. They thought this would be shut down, stopped immediately. Look, there's long-standing legal precedent around the 14th Amendment, and especially the way that Trump wrote this EO. Legal experts told me that the fact that they included people, mothers who are here legally but temporarily, and their children, even that makes it harder for Trump to in any way sort of argue the legality of this executive order. Even some of the more fringe legal theories, perhaps suggesting he maybe would have had a case in court, really shot down by the fact that Trump went so sweeping in this executive order. Look, it's still possible, of course, that this makes its way through the Court of Appeals, that it is taken up. Of course, this first case in Seattle in a very sort of liberal, more democratic friendly Court of Appeals system. But we don't know if it'll go any further, because this judge saying he thinks that it is just blatantly unconstitutional. Like you said, he thinks the matter should be settled, Kira.
You know,
well, Mary Alice, Trump and his...
With due respect to his honor, he's not taking into context Article 5 of the 14th Amendment, which says it's left up to Congress to carry it out, to make the determination. So what Trump is trying to do is, irrespective of what happens in the courts, maybe these bozos are too stupid or narrow-minded to see that his objective is to get not a constitutional amendment, but a statutory clarification under Article 5 to the 14th Amendment, defining what they're talking about, and if not that, then sending out a proposed 26th Amendment. Might be cute, but in any event, he's going to probably, well, I hope his lawyers are bright enough, or the U.S. lawyers through the Department of Justice are bright enough to get the point of invasion and or go forth from there.
Team knew this
So
executive.
let's see what happens. I think they're going to round up, and they got a lot of people in custody, and they're going nowhere. That's sort of your case is on appeal while you're doing time. You've been fined, locked up. You don't have a bond set. So you stay there until it's resolved. So that, amongst other things, is acting as a deterrent to those who are lined up crying at the border, saying, we can't get in anymore. We were coming up here counting on Biden winning, and we've been watching for months or weeks. And we came over from the Middle East and China and all this, and we knew we were going to get in, and we are so disappointed. Oh, wow.
Likely issue legal battle. So why did he sign it anyway?
He promised to. I talked to one legal expert that said maybe this was just red meat to the base. Maybe it was just trying to make good on a campaign promise. It now kind of punts the issue. I mean, there's always the chance that Congress wants to try to amend the Constitution. There's always the chance that Trump will now try to issue a more targeted or more limited EO, chip away at the concept of birthright citizenship. Perhaps he could get away with something much, much more limited in scope. But you're right. I think that a lot of legal experts and probably the Trump team as well knew that something so sweeping was going to be struck down, but he was trying to make good on a campaign promise. And it's interesting, of course, in this bigger conversation about immigration. This is a part of, I think, Trump wanting to look so hardline, so maximalist on the border, Kira.
Oh, shut up. You should have had somebody like me who is a little bit more expert than your experts coming in to explain the nuances. You see, that's why I said, let me interrupt, because I knew somebody was going to come up with this stuck on stupid. So I didn't want to be, I'm copying him. No, I said it before you heard it from these idiots. So anyway, they don't get it. That's only a small part of it. It's not throwing red meat out there. As I said, my prediction is it is to provoke legislative effort or to, she even said, so Congress can amend the Constitution. Congress cannot amend it. They can only propose amendments that have to be ratified by a certain percentage of the states. Now, there's another way entirely. There can be a constitutional convention called, that's set forth in the Constitution, but one has never been called in this country's history, and I think we shouldn't, because it's too dangerous, because we're likely to get a knockdown, drag-out battle with a lot of idiots like this who are trying to put their 3 cents in the mix without knowing what the hell they're doing, and you're liable to get a disaster. The Constitution works pretty damn well as it is. So anyway, it ought to be interesting.
Let me just put my little quick cent in it, 1 cent. The Biden administration caused this problem. They allow people to come here illegally, and they knew what they were doing because they did it the first year they opened up that border when he was sworn in. So if you're going off of the metric of if someone is here for at least 2 years, then they can apply to be a resident. Well, a lot of these illegals were technically here for at least 2 years. However, the birthright citizenship, there have been these anchor babies being born here, which is illegal, to where they have set up anchor baby hospitals in certain cities in California, which is illegal. So the whole process, the whole operation of these anchor babies, which is an operation that was created, is against the law. So him signing this executive order of birthright citizenship, ending it makes sense because a lot of people were abusing it. They were not following the law, and they were still breaking the law. So,
okay, you just said something. Somebody.
Let me just say one more thing. Let me just say this one more
that point.
Right. Let me say this one more thing. What he is doing with these executive orders, specifically with these illegal migrants, let's call it what it is. He is cleaning up the shit that the Biden administrations and even prior administrations, have allowed. But he is really cleaning up the shit from the Biden administration because they allowed these illegals to come here illegally and break the system completely.
Well, there's a remedy to that. It's been on the books for a long, long time. It's got to do with harboring federal fugitives. Title 8, Section 1324, etc. And it makes it a crime for people to do what they're doing, giving aid and comfort, soliciting, providing transportation, housing, all that stuff for any person who is illegally here. So all of these people that set up the hospitals, the care facilities, provide food, benefits, and all of that, they are engaging in a conspiracy to violate the law. 8,
Exactly.
1324, etc. And the penalties are interesting. These situations where one of these illegals has killed somebody, raped somebody like that, the maximum sentence for the lowest level of this harboring the fugitive border crashers is 5 years maximum. For other offenses within this section, the death penalty is appropriate when one of the people that comes in kills somebody, or life in the penitentiary. And that goes down to one for 20 years where there is a reasonable threat posed to somebody's life or physical well-being by one of these immigrants that's let in. So we haven't heard the last of this. It might be very, very interesting. And what has been going on is the clear violation of the law has been happening for the last 4 years because of the prosecutorial discretion exercised by the Department of Justice and the Attorney General under Biden-Harris to not prosecute. But that can be swept away, and it is being swept away by the Trump administration with the lady that they're proposing. I'm sure with the lady they're proposing to be the new Attorney General, whose Justice Department will go kick some ass. So I would suggest to them, as a pragmatic matter, to get it out of the political arena, just request the appointment of a cadre of special prosecutors, get the I's dotted, T's crossed, let them go for it. And let the confinement begin.
All right, guys, thank you so much for tuning in. This is the conclusion of Injustice for All, episode 4, part 1. Stay tuned for part 2, where we dive into the DEI executive orders.